Ekulina all-rise. Penohone ka'aha ho'okolo ho'opi'ikue, o kaluna kanawai hano o Catherine G. Leonard, ame kaluna kanawai hano o Karen T. Nakastone, ame kaluna kanawai hano o Sonia M.P. McCullough and O'Malley. The Intermediate Court of Appeals is now in session. The Honorable Catherine G. Leonard, Karen T. Nakastone, and Sonia M.P. McCullough presiding. And Noho Ilao, please be seated. Case number CAAP-21-0024, ForOurRights, a Hawaii Corporation, Levana Lomma, David R. Hammond, Randy Hammond, Janet Eisenbach, Levana Lomma, Kate Plaika, Lawrence K. Pell, Geraldine Shokine, Leonard Shokine, Daniel Hashimoto, Christina Cole, Francesca Wolper, Naya Lindsay, Michael Mazzone, Lynette J. Harley, and Lorraine L. Patch, plaintiffs appellants, versus David Y. Ige in his official capacity as Governor of the State of Hawaii, Claire E. Connors in her official capacity as Attorney General for the State of Hawaii, and State of Hawaii defendants appellees, Marc Victor for appellant, Nicholas McLean for appellee. Argument on merits.
Good morning. Counsel, would you like to make your appearance?
I would. Thank you, Judge. Marc Victor, on behalf of the appellants who are also plaintiffs in the case down below, I want to also wish you a happy Wednesday, and also say good morning to opposing counsel and everyone else in attendance. I'm with the Attorneys for Freedom Law Firm, and we are in Bishop Square, just a few minutes walk from here. Would you like me to start my argument now?
Not just yet.
Okay.
Good morning. Would Kelly like to make an appearance?
Yes, thank you, Your Honor. Nick McLean for the State Appellees. I'm the Deputy Attorney General in the Department of the Attorney General, and with me at the council table is the Solicitor General, Kim Peter.
Good morning. This is the first in-person oral argument held by the Hawaii Appellate Court since before the first emergency proclamation in March 2020. And it's really nice to see you all here this morning. We appreciate you coming here, and we appreciate your compliance with the Chief Justice's COVID-related orders, especially with respect to the wearing of masks throughout this hearing. Now, if you look at me, you'll see my glasses are steaming up, and I don't like the mask any better than anybody else in this room. I'm quite sure of that. But I really would appreciate your compliance with that. Normally, attorneys would stand at the podium to make their arguments, but that was going to require various additional COVID protocols. So, counsel, you will argue seated at the tables where you are, where you each have your own microphone. We'd like you to remain seated if you would. That way you can look at your notes or whatever if you like. And in addition, if you're seated at the tables, we were able to remove some giant plexiglass barriers that would otherwise benefit you and the court. So, Mr. Victor, I understand you have reserved 5 minutes for rebuttal. Is that correct?
That's right, Judge. Thank you.
Please proceed.
Members of the panel, and I appreciate the court's comments, and I'm honored to be here for the first oral argument. Members of the panel, this is really a case about, I would say, the fundamental tenets of a free society. It's about our legal philosophy, what I would call our bedrock, most fundamental principles. We here in Hawaii, as well as in the United States generally, we seek to avoid concentrations of governmental power. The reason for that is because fundamentally, we're skeptical about government power. We believe in the separation of powers. The reason we believe in them, and I'll quote that oft-quoted mention from Lord Acton, we believe power corrupts, and absolute power corrupts absolutely. That's why our government is limited in delegated powers. We reject the idea that government has all the power unless they're specifically limited. Now we had a case, there's one case that's mentioned in both briefs that I believe is actually on all fours with with this case. It's the Wisconsin case. It's in both of our briefs, and I'm sure you've looked at it. But I do want to give you a very short quote from that case. I think it's very applicable here. It says, and I'm quoting from the favorite case, "Our constitutional structure does not contemplate unilateral rule by executive decree. It consists of policy choices enacted into law by the legislature and carried out by the executive branch. Therefore, if the governor has authority to exercise certain expanded powers not provided for in our Constitution, it must be because the legislature has enacted a law that passes constitutional muster and gives the governor that authority." And as I've said,
Sorry to interrupt you, but can you confirm that you did not seek relief with respect to the initial March 4th, 2020 proclamation? In other words, you don't challenge the governor's authority on the first one. Is that correct?
it's clear under the statute that the governor has the emergency power, assuming that statute is constitutional in the first place. Absolutely, he has the power to enact the powers that are specifically delegated to him in that emergency declaration. So we don't challenge that.
Okay, so, and you just said an interesting thing, which leads to another question, which is, does the complaint as currently drafted allege a constitutional challenge to any part of Chapter 127A?
It would only be if, I think this court should only reach that question, if, and this is the same exact thing that happened in that favorite case in Wisconsin, this case could be completely resolved without the constitutional question. You only reach that question if you adopt what appellees believe is the construction of that statute. We think, and I'm going to go through that statute, we think the statute's very clear on its face. But if you adopt their construction, which essentially would allow the governor to continually declare another state of emergency on essentially the same fact, then, and only then, we would argue it's an unconstitutional delegation given to the governor. But it's only if you find appellee's construction is the appropriate construction.
Okay, so just, this is our only chance to chat, so explain that to me. Why, if we adopt appellee's interpretation of 127A 14, why does it become unconstitutional?
Well, it becomes unconstitutional because what we have essentially is what we have now, which is one person, the governor, the executive branch, exercising for an indefinite length of time until the governor decides it's appropriate to relinquish those powers, all of the powers that are delegated, which are very broad and sweeping powers, very broad and sweeping powers. If he can exercise that kind of authority for an indefinite period of time, what that essentially means is the legislature doesn't have to legislate. They are delegating far too much power to the executive for an infinite period of time.
Okay, so what we're here today on is an appeal from a dismissal order.
That's right.
Okay, on a complaint that has 2 counts. I don't see a constitutional challenge of that nature in the complaint, Mr. Victor. Can you point me to it?
I can't specifically point you to that. You're absolutely correct about that. But nonetheless, this court can rule sua sponte on a constitutional issue if, in fact, the court finds that there is an unconstitutional delegation here. But as I've said, the thrust of my comments today are not going to be on that issue. The thrust of my comments are going to be simply focused on the statute. The statute is clear. And in fact, unless the court has other questions, I'm going to get to that very quickly. And so, HRS 127.8, that's the statute really we're talking about here. And there could be 2 aspects of this, as we just discussed. The one we're focusing on is the governor exceeded that delegation. And that goes exactly with what the Wisconsin Supreme Court said. It doesn't say in the Constitution the governor can do this, only in that statute. So I'd like to focus on that. 127.8, the emergency powers here, frankly, to me, makes perfect sense. I don't challenge the statute as written. because emergencies occur. We know this in Hawaii sometimes, unfortunately, better than other states. Emergencies are going to happen. And it's just a fact of life that the legislature may not be able to convene a special session quickly enough to deal with that emergency. Things need to be done immediately. This is why it makes sense to allow the governor in that statute to unilaterally decide what's an emergency, because there's no time to debate this question. But of course we should recognize here, and I think the legislature did, that there is serious potential for abuse, even on this point right here. What's an emergency? This is...
Okay, but you didn't challenge the emergency here, Mr. Victor. You challenged the procedure. So I think it would be helpful to the court if we, focused on that part of it.
I'm only getting into that, Judge, because I think that the underlying purpose of the statute, of what we're trying to get to what's the legislative intent here. And I think it's important to understand why they limited this to 60 days. And part of the reason why is because there's lots of potential for abuse here. As I've said, what's an emergency? This could be virtually anything. I mean, I could imagine we could have an economic crisis that maybe a governor could say this is an emergency, a big storm. How big does a storm have to be? How bad does a flood have to be? Could a governor declare an emergency because there are questions about maybe legitimacy of an election or something like that? There are infinite possibilities. But we can't have debate on this point. This is part of the reason why the legislature circumscribed that power so tightly. Also, what laws are necessary? There's no time for a legislature to get together and figure out what laws are actually needed here. There's lots of potential for abuse. Actually enforcing those laws, those are the typical duties of the executive. In non-emergency times, this is a big concern. This is exactly why we have separation of powers, because we don't trust any executive to completely execute the laws without being checked. So there's potential for abuse there, but in an emergency, we acknowledge those risks. The only limit we have, reasonably, is how long it lasts. That's the only way to limit this. And that's what we're challenging.
Doesn't the Chapter 127A itself have a mechanism for seeking relief? I think I'm talking specifically about 127A27. Which is the procedure for injunctive relief.
It does, and then...
So there is a check by the court system that is contemplated in the statutory system.
Well, you're absolutely correct, and that's part of why we're here today. And if we were going to raise the lack of a private right of action, that's exactly the section I would have focused the court to. But there's no check other than us bringing a lawsuit in this statute. And the legislature doesn't presumably pass a law with the idea in mind that the way to check the governor is some citizens need to get together, spend some money on a lawyer, and bring a court action that comes almost 2 years after the governor's declared his first proclamation. I'm simply saying in the statute itself, there's not a check there. But I think, and I'm going to invite you, and you probably have already done this, to really carefully look at the wording of the statute. I think that this case could be entirely resolved simply by going carefully through that statute. And I'd like to take you through at least my thought process of how to interpret that statute. And I'm going to read it here very briefly, specifically the one at issue here, which is HRS 127A-14, subsection D. I think that's really the focus of our inquiry. I'm going to delete the sections about the local mayoral because that's not an issue here. But if I read that, very simply, a state of emergency shall terminate automatically 60 days after the issuance of a proclamation of a state of emergency or by separate proclamation of the governor, whichever occurs first. Now, there's 3 parts of this that I think each of the 3 go to give us a window to what the legislature was thinking when they passed this section.
So, Mr. Victor, pretty sure we've all read that numerous times. I know I have, and I agree with you. It says it terminates in 60 days. But what it doesn't say is that he can't issue another proclamation.
I completely agree with you here. I certainly can see that point.
Is there anything in the legislative history that you were able to glean that indicates that the governor is limited to a single proclamation?
We don't have any guidance on that point. This case will provide that guidance for future states of emergency, which I think that this is why this case is so important. But I think if we go through that language, and certainly I can see that there's nothing that says the governor can't do it. But there's also nothing that says the governor can do it. And so that's really the root of this. What's the default setting? Does the governor get to do anything that he's not specifically prohibited from doing? Or does he only get to do the things that he's specifically granted authority to do? And I would suggest our entire government is set up with this idea of limited powers in mind. The shall terminate automatically seems very clear. It doesn't say.
Well, let me just back you up to Part A of that same statute, which, and I'm sure you've looked at it too, Mr. Victor. It says the governor may declare the existence of a state of emergency in the state by proclamation if the governor finds X, Y, Z, a lot of which are defined terms. I know you've looked at that because you're not challenging the first proclamation. But it does seem to say that the governor can issue a proclamation if he finds certain circumstances exist.
No question about that, Judge. I think that's absolutely true. What it doesn't say is he can't continue to issue a state of emergency, to reissue a state of emergency based on the same, or I would argue, substantially similar facts. It doesn't say that at all. It would overthrow the entire meaning of the statute. I think, it doesn't say shall terminate automatically unless. Other states say that. There are several of these cases where the governors, the appellees, have actually cited those cases. In those cases, the statutes say those types of things. Ours doesn't. It doesn't say the proclamation may terminate in 60 days. The legislature opted for shall instead of may. They could have certainly delegated power like other states did until they acted. Other states did that. Hawaii didn't do that. They could have delegated until the governor relinquished power. Other states did that too. This legislature didn't do that. Our task isn't to determine the wisdom or lack thereof of what the legislature did or didn't do, or even what the governor did or didn't do. Our task is just...
How do you propose that the court construe the or clause then? It says or by a separate proclamation of the governor or mayor, whichever occurs first.
I think this is an excellent observation. Thank you for that question. It definitely contemplates a second proclamation, but only for the purpose of terminating the first proclamation sooner. I know appellees certainly argued, yes, there's a contemplate on page 9 of their brief, actually. They said, yes, it does have this other or. And I think it's very interesting because this language, whichever occurs first, is put in there. If they delete that language, imagine we just delete that language, whichever occurs first. In other words, it terminates in 60 days unless the governor issues another proclamation. That's the reading appellees want you to adopt. They want you to read out of the statute those last 3 words. But those last 3 words are there for a reason. They also could have said, this would have changed it as well, whichever occurs later or last. Presumably they were aware that they could have drafted it that way. Had they said that, we wouldn't be here. Because that contemplates that the governor can actually issue another proclamation that extends the first proclamation. They didn't do that. I also think the word "a" in there is very important. He gets to issue a proclamation. It doesn't say any proclamation. If it said any proclamation, we wouldn't be here on that either. That gives me a signal. It gives us a signal that the legislature is thinking that it's possible that the governor could actually proclaim another state of emergency based on the same facts. So I think we do need to read it very, very carefully, because what we're talking about here is a grant of substantial power here. This isn't just a small grant of power. Now, admittedly, it's necessary. Everybody, I'm not contesting that. Our side is not contesting. Emergencies happen. We need to have this section. The only question is, doesn't need to go on past 60 days. Some places it does, because in other places the legislature has no ability to reconvene. In those situations, maybe it makes sense. But here in Hawaii, we have a legislature that can call a special session. So if we look at the underlying thought process involved, why would the legislature pass this and use such clear language? Because as the appellees argue, yes, the emergency could go on for a long time. They speak as if it's an absurd result, I think is the language that they use. By saying, well, the emergency could, of course, go past 60 days. They give us a parade of horribles with things that could happen. Of course that could happen. This doesn't foil our reading of this statute. All it means is 60 days is contemplated for the legislature to simply get together, and they can do anything they want at that time. And maybe they would have. Maybe they would have gotten together and said, you know what? This corona thing is a really serious emergency. We're going to extend the power of the governor to pass.
Perfect. So you brought up that they can call special sessions, right? So they did 5 times in the last 2 years, and they've had a regular session, and they didn't address these 60 days or make any amendment to curtail these proclamations. Is that tacit approval?
I would say no. I would say our task isn't to determine what the statute means in the context of what the legislature has done in the past, or even what it's doing now. I understand there are bills pending right now to terminate the governor's authority. But I don't follow them, and neither should this court, unless and until they actually become law. Politicians do things for re-election purposes and other purposes all the time. To have this court interpret a statute based on...
Sorry, GM, I think it's GM 1157 maybe, did become law, and that actually refers to the proclamation that the governor had issued. And so it's an eviction moratorium.
I see. Yes.
And so it refers to the proclamation. Isn't that tacit approval?
I would say no, it's not tacit approval. This is one aspect of one part of the authority that the governor exercised. This has nothing to do with the fundamental power of the government, of the governor to continually exercise power. So I think to take a look at what the legislature did and glean from that what the understanding of a different legislature at a different time, what they actually wrote, even if they wrote something different or something was pending today, completely contrary to what they actually wrote, our task is to focus on what the law is right now. And the law right now, or the governor's authority right now, is still based on this very section, which has not been altered. The actual section itself has not been altered by the governor. So I would say no. There are many things going on out in the political world that really are not the jurisdiction of this court. I think our focus should be limited simply to what does this law mean that's on the books right now. And the net effect of the law, as we know, is we now have a governor. Again, I want to be clear about this. I certainly don't mean to say that I think the governor has done anything in bad faith here. Our argument does not depend at all on anybody acting in bad faith here. In fact, we could even take as a given that everybody is acting in good faith here. Maybe the governor's done exactly what I would do if I was governor. That's not the point. The point is, there's going to be another governor down the road. There'll be other states of emergencies down the road. I remember having a discussion with a U.S. attorney one time about the Patriot Act. And he said, well, we would never misuse that. We have good people here in the U.S. Attorney's Office. Well, as it turned out, we got different people who have done different things over the years. The same is true here. So the issue isn't the wisdom of what the legislature is doing now, or the wisdom of what the governor is doing now. The issue is, what does this say? This huge grant of power, which I think if we read very carefully, as I very quickly went through, I think the letter A gives us some guidance. They didn't say any proclamation, they said a proclamation. And I think this whichever occurs first language, if we really think about and contemplate, I'm sorry, I can barely see with the glasses steaming up, and I apologize for that. I think this language whichever occurs first is absolutely telling. I think if we just focused on that and even forgot about everything else, if they just didn't use that language, I would agree with the police construction. If they used later, no problem. But they used first. And I think if we think about that language, it tells us everything we need to know about what that statute means. And also, this Latin phrase, which I'm going to apologize in advance that I'm going to completely butcher here, expressio unius est exclusion alterius. As we know, this is a basic rule of statutory construction. They said one thing. We can infer they didn't mean the other things that they didn't say. First means first. It doesn't mean last. A means a, not any. Shall terminate after 60 days means shall terminate, not may terminate. I don't know how they could have written this any more clear than they did. I also ask you to think about how dangerous a point it would be if we just simply said, well, it doesn't say he can't do it, therefore he can do it. I mean, just as sort of a thought experiment, what if the governor just simply said, look, it doesn't say I can't assume full control of the courts as well. In fact, if you look at the statute, there's probably a stronger argument here for that. I look at 127.812, which discusses his powers, and I look at section B5, specifically allows the governor to seize control of all public buildings, including this building right here. And it says he may, not he shall, he may make alternative provisions as he deems advisable. I see nothing.
So Mr. Victor, I appreciate that. But let me segue into another question because your time is growing short here. If we were to reject your claim based on the statutory interpretation, what about the circuit court's ruling on your second count? The court said, quote, plaintiff's claim in regards to the vagueness of prior emergency proclamations, which are no longer in effect, is deemed moot and is dismissed with prejudice. Now, you raised some arguments about exceptions to the mootness doctrine. What happens if we were to vacate the court's ruling on that second claim as on mootness grounds as to that second cause of action, assuming we rejected your statutory interpretation?
Well, certainly the court can do whatever it wants here, and I think the issues are of grave constitutional significance. I think the strongest arguments are based on simply the statute and means what it says, and we shouldn't get past that. If you do get past that and accept that the governor can do virtually anything that he's not specifically prohibited from doing, which I think is a very scary proposition, frankly, then I think we could certainly find that this is an unlawful delegation and not have to go any further because so much power, I mean, I think it's obvious.
So are you abandoning your second cause of action?
No, I'm simply saying we shouldn't reach it. If we do get past the unlawful delegation, there's all kinds of issues here that is very difficult to interpret. I think questions about where you have to wear a mask and don't have to, there's endless issues here that haven't been ferreted out. People have been cited for wearing masks on the beach. It's not clear how far they can be. It's not clear on many, many issues. So yes, there's an endless possibility of vagueness, but I sure hope the court doesn't get us there, because to get there is to necessarily say initially that the governor can keep doing this until, as the other side says, they say, look, essentially trust us. At some point, the governor will decide the time is right and he will relinquish power. That's not the way a free society works. And so I would simply say, yes, the court could get there. Yes, the court could make that argument. I certainly hope the court won't even get to the unlawful delegation, because I don't know what the legislature could have done short of saying, we really mean it, or short of saying very clearly, the governor can't declare another state of emergency on exactly the same facts. But if I was in the legislature having this discussion, I would say, why would we have to say that? We've already said it shall terminate 60 days. There's no possibility of it going past that, unless he issues another proclamation which can only terminate it sooner.
So Mr. Victor, as I understand it, the circuit court did not reach the unlawful delegation question. Is that correct?
That's my understanding as well.
So, do you think that that is even before us, or just the court's ruling on the statutory interpretation?
Well, I think that certainly if you find that that issue is not moot, and you get past the other issues, you could make a ruling on the merits of that issue. And I think it should not be moot, because obviously this entire matter, and I know mootness was raised by appellees, but if there was ever an issue that evades review, it's this issue, because there's only 60 days here. I mean, look how long it's taken us to get to this point. So I see my time is up, and I wanted to make sure I can reserve at least 5 minutes, so thank you.
Thank you, Mr. Victor. Good morning.
Good morning. Thank you, Your Honor.